I think that it's important to note that a lot of these requests being made, at least by Ms. Gibson, are pretty extreme in light of the fact that this case has only been before the court one time on a post-judgment issue for transitional kindergarten, but that issue was resolved by agreement. Many of the complaints also listed by Ms. Gibson are related to issues that occurred in 2023 and early 2024. The court hadn't even really seen these parties during the divorce case. It's because they were able to work it out. I think it's notable that mom's motion was filed really after dad made a request, which we made in our motion, to receive reimbursement for his daycare expenses, that she really forced him to pay despite the court order. Ultimately, really after reading through everything that was submitted, I'm of the firm belief that these parties would be well suited, and it would be best for the minor children in this case to attend co-parenting classes with Marge Lucas. I have had a lot of success in my other cases. I attached detailed information regarding her co-parenting classes to my response. Nearly really every issue raised in these motions, besides the support and daycare issue, are related to issues addressed by Ms. Lucas in her classes. This is substantially cheaper than a request made by opposing counsel to utilize Ben Burgess, who I understand is $7,500 to $10,000. Ms. Lucas's classes are done at a fraction of the cost for both parties. It's an 8-week course. It would be $760 a person. And ultimately, that's what we're requesting, Your Honor, today, is that the court order the parties to attend those classes. With respect to the actual issues regarding this case that are related to co-parenting, we have, really an issue of physical discipline. The judgment provides for no physical discipline. My understanding is opposing counsel's indicating none was done. She's complaining about my client recording the minor children repeating statements they made to him. My client wasn't using that for any purpose other than to inform mom that this was what was being said. It wasn't used for court. It's not meant to do anything other than try to ensure that the children are being safe and feel comfortable at both homes. My client would like to know if the children are saying anything about him during mom's parenting time. The recording was done because Ms. Gibson doesn't believe anything my client says verbally, but ultimately I understand the court's position that stuff has not been happening and will not happen. If the children raise issues with him, he will work with plaintiff in order to ensure that he's providing her the relevant information so that she knows how to react and how to communicate with them moving forward. I would note that unfortunately in this case, this isn't just a matter of the kids having just any single bump and bruise. These were issues with bruising on the face, bruising on the hand, like the minor child running away, screaming and crying, saying she didn't want to get spanked. I mean, these are things that were happening. They aren't currently happening because my client made Ms. Gibson aware that CPS had advised him to document, which is what led to him bringing the children into urgent care and recording. But after discussion with me, that's not going to continue. If there are issues that are relevant and deemed worthy of a CPS investigation, that's obviously the route that would be taken. But again, the hope is it's not an issue since opposing counsel's indicating that Ms. Gibson is not using physical discipline. With regard to information being provided and filling out forms, I think much of this case will be resolved by just each party filling out their own information for the relevant care providers. I indicated in my motion that there has been a lot of concern related to Ms. Gibson filling out forms, not providing the care providers that my client's a custodial parent. I provided proof of that. I know she wants
Dad's lawyer calls mom's request extreme and lays the groundwork for a tense showdown.
Wants to poo-poo it and say, she didn't do that. It wasn't her fault. He should have figured it out. He did his best, right? He had to work with the school for months to figure out why he wasn't getting emails. The emails were going to Ms. Gibson because he was signed up under her email under data access. When he signed up for the kids, he couldn't select data access because somebody under his name already had done so, and that was mom. This is something that was happening at the daycare. There has been an alignment issue here. Again, the hope is that this co-parenting class can assist the parties in moving forward and to ensure that this does not continue. With respect to the request regarding the OFW, my client's happy to use our family wizard. They've been using it. He would like the court's formal order to be entered so that the parties are responsible for inputting information on the calendar within a certain time frame, and responding within a certain time frame, and that will help the parties. We have a request, Your Honor, in our motion related to mom looping dad in on where she's going to be with the kids. Typically, mom's communication to dad is, hey, we're going to Wisconsin, really little notice, doesn't say where they're going. All my clients really asking for is pretty typical in these cases, is if they're going to fly, take a bus, or go on a train, that he be given that information, and then just know the city that they're living in, or not living, excuse me, but visiting, so that he can ensure that he knows where they are in case of an issue. If the plane crashes and my client doesn't know whether they were on a plane, that's really concerning. Obviously, that's an extreme example, but it's just information that most parents would want to know, and they should be able to be entitled to that information. It's not to micromanage her. It's just knowing where your kids are. And unfortunately, mom refuses to provide that, while dad is absolutely happy to provide her that information. With regard to the request for a speech evaluation, this is not a suggestion by any third party in this case. My client was told by Ms. Gibson originally that this was some sort of referral from the children's primary care providers. That was not the case. And once he found out, he did decline to do the speech evaluation. The children are in daycare with my client, and the daycare facility has not noticed any issues with their communication. My client would really like to avoid having the children be evaluated if they don't need to be, for any purpose. I think it puts them in an awkward position. And ultimately, if a third party recommended it, that was a care provider for the children, such as daycare or their doctor, certainly he would not have an issue with supporting that. But at the end of the day, he doesn't believe it's a concern or necessary. Again, I think I know we talked a little bit off record about this. There's a request by mom to have the parties attend appointments every other appointment and just be responsible for scheduling every other appointment. The parties have actually worked really good together regarding appointments. My client hasn't canceled a single appointment mom's made. He has never, she's canceled one that he's made, but ultimately they have been working together fairly well over the last 2 years to ensure that both of them are able to attend these appointments. This is probably really relevant in this particular case because the kids are young and there are legal custody decisions that are typically made at these well child visits. So both parents should be privy and available to attend those. I also don't think that there's a need to really micromanage these parents in this way when that has not been an issue. My client also has this other co-parenting issue with respect to preschool. My client was asking that their children be enrolled in Greenville's Junior Jacket program, which is a program that they have as a preschool prior to transitional kindergarten or kindergarten. These children will turn 5, I believe, on September 5th.
They're 3.
Or excuse me, 4. I apologize. We'll turn 4 on September 5th. So ultimately, my client had requested that they attend this daycare. Their other child was able to attend a preschools type program at their last daycare. He believes that these children should be able to do the same, and believes that they're best served by going to a preschool program at Junior Jackets. I understand mom's position that she wants to ensure that the children are spending time with her as well. My client agrees. He loves spending time with his kids, but they just wants them to have an educational opportunity. My understanding is that there's a 2-day minimum if the parties have a joint account with Junior Jackets, which means basically that's how they fund Junior Jackets. If they do, 2 days is the minimum, and they could be permitted to have the education during that time. Again, it would also reduce the cost of daycare since the kids would not have to go to daycare on those days. There are a few other issues that were raised in these motions, Your Honor. One was regarding daycare. While it's really a matter of cost at this point, there was another issue with not getting equal information, which was similar to what happened during this last school year with their oldest. The prior daycare was employed by mom before dad got involved, and it was right when the divorce was filed. The parties utilized that provider. But unfortunately, mom had sort of laid this groundwork with the staff there, and it seemed that people were aligned. This resulted in dad not being able to get a key card for the daycare until the divorce was finalized. Dad wasn't even able to
Dad's side paints a chilling picture of bruises, spankings, and CPS warnings, raising real stakes.
get crafts and gifts made that were sent home with other kids on parenting time days, but he wasn't allowed to have them. So he would see kids walk out with stuff. Their kids weren't getting it because it went home with mom only. It was really just quite egregious. He also received a private message from an individual who was employed there, noting that these were issues that were occurring. So then he submitted a subpoena, which obviously opposing counsel referenced in her response. It is also notable that she had access to teachers, but he only had access to the director. It did become a problem. Eventually, there was obviously a clear bias. Both parties, it was notified, or it was known that my client didn't agree to have the children's education being done there any further. So the parties had originally agreed to seek an alternate daycare. The parties had initially had communication back and forth. Mom wanted to tour some facilities that dad had looked at, but she never.
Sorry to interrupt, Ms. Van Tol, but
Yes,
I've read all of this,
I know.
so if you,
Okay.
if
Yeah, I get
shorten
it.
it up a little
So, I
bit.
mean, the issue ultimately, Your Honor, is now mom has basically forced this daycare arrangement where my client's been required to pay for his own daycare. This is a request that mom's been making since the divorce was entered. She doesn't like that she has to pay more daycare. She makes substantially more money than my client. She had been historically living for free with her parents. So throughout this last school year, my client has been paying daycare on his days when he works. And then in addition to that, my client, because mom set it up this way, has been responsible for before and after school care for their oldest on his days. Again, this is a forced request by mom. She's basically forcing him to pay despite the court order. She's asked for this agreement in the past. He has completely declined that. Again, there is a huge disparity of income here. And ultimately, he's asking that the court have the parties exchange daycare cost information and proof within 21 days so that we can do the calculation, hopefully without having to come back to court. The court order remains. There is no basis to deviate from that. There's no retroactive modification. This is no different than if someone had a medical expense, but ultimately mom wants to complain that she wasn't provided daycare information. I'll note the other daycare provider was harassed. They quit. Mom didn't provide her daycare provider information. So either way, it just has an issue that needs to be dealt with. With respect to the issue of support, mom's noting that she has $30,000 of decreased income. This is unknown to my client and the timing's a little suspicious, but either way, if the court's inclined to send this issue to the front of the court for an investigation, that's fine. I noted in my response that my client is working as a parapro. He is engaged in largely full-time hours almost every week during the school year. He also picks up work as a coach and athletic director. I don't think it's appropriate to impute him since he's working to get education as a teacher through the Grow Your Own program through this school. With regard to the transportation, mom's requesting that her parents do transportation. Back in, I believe, 2023 or early 2024, there was an issue with mom's father being inappropriate in exchange. My client was very concerned about that, raised the concern, and indicated he did not feel comfortable moving forward with him going there. The incident resulted in the minor children not wanting to go with her dad, and it's just an unnecessary issue. It hasn't really been an issue. Now mom wants to utilize her parents. He's not comfortable with that. He's also concerned that she's saying that he can't record during the exchanges. The kids can't see him recording. The phone's in his pocket. It's just for the verbal. He's concerned about false allegations mom's raised about him in the past, and he does not want that to happen moving forward. And then I believe finally the one issue that another issue raised by opposing counsel is counseling. Again, no third parties indicating that this minor child needs counseling. She does well educationally. She does well socially. Again, dad's concerned that mom's prior attempts to align individuals against him is going to continue with anybody else involved. But ultimately, the biggest issue is that no one else is suggesting that it's a concern. So we are asking that the court deny that request. Thank you.
Thank you. Ms. Tompkins.
Thank you. I'm going to try to hit the issues one by one and keep it as clear as possible. I know there are a lot of them. I'll start with that physical discipline. Miss Van Tol didn't know there was an order prohibiting that. I had to remind her there is an order. It's an order we requested. It's in the judgment of divorce. My client has not and does not and never has used physical discipline. The irony here is that she left this marriage fleeing the house in light of Mr. Gibson's physical attacks on her. So I have this whole narrative that he's trying to create. I'm not going to spend time on because it's false and diluted. I would ask that he's prevented and ordered to immediately stop recording the children. I find massive concerns with his inability to understand that what he's doing is putting false memories or false thoughts into these children's head by saying, oh, please repeat what you just said. Does mommy hurt you? How does mommy hurt you? There is a forensic interview protocol, and clearly he is not engaging in that at all. He's simply damaging the kids. This is one example of why this child needs therapy. Every single issue will continue to show why we think therapy is appropriate. As far
Travel
as
disputes, speech delays, and preschool battles reveal how far apart these parents really are.
um, co-parenting classes, I have major concerns about the idea that they want to co-parent when what my client is adamant to do is parallel parent. There needs to not be, she wants peace and appropriate communications. She does not want him engaged in her life. That's why they got a divorce. Parallel parenting is an absolutely appropriate and the appropriate method to deal with these cases of high conflict. So I have concerns about the co-parenting class and of the cost, and in the idea that it's tries to make parents co-parent as opposed to parents parallel parent. As far as travel, my client provided information. She does tell him where she's going, what states, cities. She is does again thinks this is another function of his wanting to control everything, that he will demand and want the hotel, the phone number, the every little bit of a full itinerary. I don't think that is necessary or appropriate. She is following the order that says that she will keep him notified of where she is in the event of an emergency. She has always told him if there's any kind of an emergency. So I would ask that that request of theirs be denied. As far as their daycare expense request, in child support, if someone fails to report income or hides information, they can retroactively modify an order. We have asked repeatedly for where the kids were going to school and cost information. We didn't find out until Miss Van Tol attached a letter to her motion here. We had no information about the cost. They're saying it's the same, but that's not the true. The prior daycare had more days included. So I believe the cost is higher. They have provided zero information on it. And if she had known about this in the beginning, she would have been able to go to the court and ask that there be a modification of child support to include it. For child support, that issue, there has been a proper change. He's making more income. He just acknowledged, his counsel just acknowledged on the record that he's doing more work than he was, including summer work, including now coaching and doing additional things and doing full-time work. So my client's also making about $30,000 less than she was. So I think it's appropriate to send it to friend of the court and have whatever the party's child care expenses included. That's a function of the Michigan child support formula. It should be included directly into the formula. They can each pay their own expenses. They can report that to the friend of the court, and that can be included. That's how it is divided between the parties. As far as, again, going to his daycare expenses, she also has daycare expenses with the after school cost, and she has to have a nanny every other Friday for $200. So it should all go through the friend of the court and go to child support. For transportation, he again wants to control the situation. When my client asked what her problem was with the father, he had nothing to say about it. He refused to answer or try to resolve a problem. The exchange location is in a public place that has video recorders. So he also never provided, he was happy to provide video recorders of him talking to the kid, but he didn't provide her some recording that had her father doing something wrong. My client throughout that time period lived with grandma and grandpa, lived with her parents, and the children were very comfortable with them. She has work. She cannot always be there. It is absolutely appropriate to say that the parties can provide transportation through a person known to the child, that all parties will be civil or, quite frankly, not talk at all, and that there will be, it's in a public location, there's no threat of something happening, and that we can move along. That way there isn't continued entangled problems. As far as preschool, he puts on the white hat, but he enrolled them um, without her knowing, without her agreement. They can go 2 days, and if he wants to send them on his time and pay for it and have that be part of the child support formula, she's not opposed to it. These children are 3 years old. They don't qualify for preschool. So she would like to have the right on her parenting time to spend her time with her children.
Money
I
takes
think
the spotlight. Dad accuses mom of forcing daycare costs and hiding info until the judge finally cuts in.
I think she has every right to do that. And for him to try to force her to pay for less time with her children, I think is abhorrent. My client has, again, no issue with them going on his time. If he would like to pay for them and enroll them, that's fine. As far as the speech evaluations, my client had spoken with the doctor about it. The doctor said if it hasn't cleared up or you don't see improvement, then you should seek out a speech evaluation. She hasn't seen improvement. We have a daycare provider that we don't know, from Mr. Gibson, saying, hey, I'm no professional, I have no training, but I think they're fine. My client has concerns. There's no hurt or harm in an evaluation. It's nothing strenuous. It's nothing problematic. It is far more problematic to put the children through going to urgent care visits for false bruises. So we don't see any reason that the speech evaluation shouldn't move forward, as it's a consistent concern for my client, and it does zero detriment to the children. As far as therapy, everything that we're here talking about today, I think is a very strong basis for this child to engage in therapy. I don't see how that could be much more needed than that. As far as appointments, with the doctor's appointments, I'm not requesting, Your Honor, that anybody is prohibited from attending. They already know what vaccines they agree on. They've always had all of the traditional vaccines, and they've always said that the children will not have COVID vaccines. I'm not asking that anybody has a right to make any joint legal decisions by themselves, but it is a completely false assertion that there hasn't been constant problems with scheduling. My client has had to leave work because last minute Mr. Gibson has said, well, I can't get them there. And she's had to go and pick them up. She's had issues with rescheduling, escalation, and issues. And I don't see how it's a problem to go back and forth. If they are able to attend, they can attend. It's also a very typical thing with things like therapy that they would rotate scheduling so the other one can be there. Mr. Gibson will never agree to schedule when he has to work. And the problem has become my client constantly having to try to take off work or negotiate her schedule. So he says it's fine for him because he throws a fit until she takes off work and doesn't complicate his life. We're looking to have orders that will minimize the problems as to continue to exacerbate them. As far as the daycare expense, again, I would note his bad behavior. He has spent his whole motion minimizing everything he's done. But I personally was on the phone and said, if his behaviors continue, they're going to lose this really good daycare. Ms. Van Tol and I had a conversation about that, and he persisted and persisted and persisted in harassing that daycare until they lost it. I just
Again,
don't
Ms.
think he
Tompkins,
should
I've
be
read all of
benefited.
this, so you don't need to go in depth.
Beyond that, I don't think I have anything other. Then I would like the court to consider adding that offer, deny their motion, grant my motion, and also include a prohibition from Mr. Gibson recording the children. Thank you.
Right. Thank you. I am going to order the co-parenting classes with Ms. Lucas. I realize that this is not cheap. It's $760 a person, but just listening and reading everything, something needs to change. This is horrible for these children. They're absorbing all of this conflict, even if it's not in front of them, they're still absorbing it. They know what's going on, and they're going to blame themselves, frankly. That's what the research shows. I will also enter an order regarding our family wizard. I believe that I have a pretty comprehensive order regarding what's expected, and I think it will clear up a lot of these problems if both parties follow that order. And if they don't, then they may be held in contempt. As far as the outstanding child care bill, there's, I don't think, agreement regarding whether or not the bill was less than, more than, or the same as at the old child care facility. So I'm going to order today that mom is responsible for the amount that she would have paid at the old child care facility. If that's less, great. If it's more, great. I just don't know where else to go with this because it is clear that information has not been shared. Again, our family wizard, the order requires that all bills be uploaded. There's a time frame as to when they're going to be paid, all of that. I think that will clear this up going in the future.
Your Honor, to clarify that, he would be responsible for her costs that she pays for the after school and her Friday care as well, correct?
Yes.
Okay.
We have to can we exchange within 21 days so that we have that information and we can make that work?
I think that's appropriate.
Okay.
All right. And as far as, and I'm going to back up a little bit on the co-parenting classes, the next step will be from the court's perspective. If things do not improve, there is a counselor named Ben Burgess who is extremely expensive. It's like $7,000 a person. And that will be what the court orders next. So I'm just admonishing both of you. You don't want to go down this road. You want to make these efforts. It's the best thing for your kids. You don't have to like each other. In fact, you can despise each other.
Mom's lawyer fires back, accusing dad of false stories.
But you do have to work together, just like in a business or an investment. These kids are your investments, and both of you are going to be involved for the rest of your lives with these children. So you need to put them first. Okay. Absolutely no recording of these children by either party. That is the absolute worst thing you can do. These children, especially at the age of 3, are highly suggestible. I just attended this week a judges conference where I spent an entire morning listening to presentations regarding forensic interviewing of children at this age, especially 3, 4 years old. They are incredibly suggestible. And it also puts them in the middle. So do not do this anymore. I'll order that each party is responsible to fill out their own forms for whatever it might be, so that they are in control of emails, phone numbers, contact information, all that stuff. Our family wizard should be used to provide the contact information for the school, the counselor, the whomever, but then it's up to each party to do their own sign up so that they can have access to the information directly with the counselor, the doctor, the school. I'll order that each party is to provide general information whenever they take the children out of state, including the mode of transport and the city generally. You don't need to provide copies of tickets or anything like that, but just general information that is frankly just courtesy. As far as the speech evaluation goes, there's literally no harm that this court can think of for this child to have, or children to have, speech evaluation, and that should happen. That the assessment is simply an assessment. If they don't need any further treatment, they don't have to have further treatment. But it's a rule out, and I think it's important to do, especially at this age, especially if there's any suggestion that there's an issue. Better to catch it early rather than later. I'm going to deny the request to alternate scheduling appointments. Again, I think our family wizard order will deal with a lot of those issues. As far as preschool goes, the request for junior jackets, at this point, I think that's fine, but during dad's time, I'm not going to impinge on mother's time. There's not much more time left before these children are in school. And so I am not going to order something that would intrude on either parent's parenting time. I'll refer the matter of child support to the front of the court. Childcare should be included. That's really what the formula calls for. Unfortunately, provisions such as in the party's judgment of divorce rarely works out, especially not in a high conflict case like this. It should be part of the child support. I will order that third-party exchanges are permitted as long as that person is known to the children and the exchanges are in a public location with a video that the location provides. And I'll indicate if it's the grandparents and anybody that's any kind of attention, they just don't speak to each other. Again, that is the best for these children. They don't need to be witnessing adults misbehaving essentially with each other. And as far as counseling for the minor child that was requested, I don't think this court has ever denied a request for counseling for a child, particularly in a high conflict case like this. Like I said, it doesn't matter whose fault it is, they take ownership. Even at this age, they will take ownership for the tension. They think it's something they've done. So I will grant that counseling. I'll indicate that the parties need to pick a counselor, and if they can't agree, the court will pick one. And I think that's it. Is there anything further?
As far as the speech evaluation, can we, the only times he was willing to agree to were times that she had to take off of work. I'm just concerned about scheduling for that. That was,
Mom can schedule it. I don't think both parties need to be there.
Your Honor, can my client be permitted to speak with the speech evaluator regarding his assessments of things before the speech evaluation takes place?
I would leave that to the speech evaluator. I know my grandson just had one not too long ago, and I know they spoke to both party or both parents. They spoke to teachers. They gather information from all over. I wouldn't say before. I would leave that up to the person doing the assessment. Okay.
And with respect to counseling, try to probably pick one that's in network available. Like, I'll talk to Katie about scheduling.
I was gonna say it's in everybody's best.
One is agreed upon, and if not, the court will assign.
We'll come back if we need you. Can we just ask for a status conference or something so we don't have emotions? That would be really helpful.
Yes, no, that would be great. I have no problem doing that. But it should be somebody, that's hopefully covered by insurance or, least expensive, whatever. So. Okay. And obviously somebody who also has credentials as a child counselor.
Yeah,
that's
child
important.
Play therapy.
Right.
Wonderful. Thank you very much for helping us. This was a lot.
All right. Thank you.
Thank you.
The courtroom climax, support fights, transport disputes, and therapy demands leave the judge with plenty to decide.